Major breaking news and a huge victory. As you know, Cook County, which is known as Chicago, has a gun and ammo tax that targets those constitutional rights. Well, today, a major decision out of the Illinois Appellate Court there in the First District Court just issued a win for the Second Amendment, stating that the lower court's decision to dismiss the case against Cook County should be reinstated and the Second Amendment should be advanced in the lower courts. Big news, and I think the handwriting is on the wall that we're going to win this big time, as I predicted, by the way, on January 24th, 2024. Stay tuned. Let's break this decision down in a moment. Hey folks, I'm Mark Smith, host of The Four Boxes Down, a proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Major win today. Congratulations to the plaintiff, Todd Vandermeide. That's right, Todd Vandermeide. Big win. We talked about this case after oral argument took place in the Illinois Appellate Court, First District there in Cook County, which is Chicago, in the Vandermeide case against Cook County. I predicted it was going to be a big win. That's right. Even though the appellate court appears to be liberals, they ruled unanimously in favor of the Second Amendment on this point, specifically whether or not the lower court, the trial court in Chicago, wrongfully dismissed the Second Amendment challenge to the Cook County ordinance that taxes firearm sales and ammunition sales. Major win. It was crystal clear that the court accepted really all of the arguments in favor of the Second Amendment plaintiffs, including Todd Vandermeide's attorneys, and big win. Keep in mind, I'll put a link to this case down below when I get a chance. And what's very interesting here is that every single argument advanced by Cook County was specifically rejected. The court came out and said that the decisions made by other courts on the issue of taxing constitutional rights were basically abrogated and could not be followed by the lower court any further. The court went on to say that Cook County, which had argued that plaintiffs did not allege enough facts to state a claim that the tax ordinance violates the Second Amendment, that was simply false. And this is very good news, because one of the things we've talked about on this channel is one of the words the United States Supreme Court has never specifically defined as part of the Second Amendment is the word infringe. As you know, the text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." The Supreme Court has defined every single word in the Second Amendment, except it hasn't expressly defined the word infringed. Now, I have explained repeatedly that this is not a big deal, because if you simply look at the same exact founding era dictionaries that were written at the time of the founding by the lexicographers that the Supreme Court relied on in Heller to define the other terms in the Second Amendment. Specifically, you want to look at the English lexicographer Samuel Johnson, who was English and hated Americans, by the way. He was not a fan of the Revolution, set that issue aside. But Samuel Johnson, the English lexicographer, defines to infringe to mean to hinder or to destroy. The Supreme Court relied on Samuel Johnson's definitions for the rest of the Second Amendment. They didn't specifically talk about infringe, but guess what happened? As I predicted was going to happen, this Illinois Appellate Court, despite being liberals, actually embraced the definition of Samuel Johnson in this opinion to define infringe to mean to hinder or to destroy. The court says that the defendants claim that infringe meant to violate or to destroy, and then they cite till Samuel Johnson from 1755, the dictionary. Well, here's what's very interesting. The Illinois Appellate Court goes on to say that defendants thus contend members of the founding generation would have understood that the legislature could regulate the conduct protected by the Second Amendment so long as such regulations did not destroy the underlying right. Defendants contend that this interpretation finds support in the recent Supreme Court decisions of Bruin and Heller, because those cases each mentioned that some regulation of the right to bear arms was permitted, but according to the defendants, the regulations addressed in those cases were unconstitutional because the laws effectively destroyed the plaintiff's right to keep and bear arms. So that was the articulation by this court of what Cook County was arguing about, that the fact that a tax does not infringe upon the text of the Second Amendment. But what did the court ultimately conclude? I think you're going to like it. Let's turn to the videotape and see how much you're going to like what the court just said. Although the defendants rely upon Samuel Johnson's dictionary and claim that infringe means to violate or destroy, they left out that Johnson's definition was, quote, to violate, to break laws or contract, to destroy, or to hinder. That's right, to hinder, italicized by this court. And then they quote specifically, of course, a dictionary of the English language, a digital edition of the 1755 classic by Samuel Johnson. So there you have it. After the appellate court in Illinois defined to infringe as to include the word to hinder, which is what we've explained is the right definition, relying on Samuel Johnson's definition from 1755, which the Supreme Court relied upon in Heller for all the rest of the Second Amendment, all the other words in the Second Amendment, the court goes on to say that the plaintiffs in support of the Second Amendment, including Todd Vandermine, had indeed alleged a proper cause of action against Cook County for violating the Second Amendment because a tax on the right to acquire ammunition or a tax on the right to acquire firearms is indeed a hindrance to the right of the people to keep and bear arms, because you cannot keep, which means to possess, or bear, which means to carry, handguns or guns without, buying ammunition or acquiring guns. And in order to do this, if you have to pay a tax, that is a hindrance because you're making it more expensive, and that additional cost is indeed a hindrance, which is, of course, means it's an infringement as defined by the 1755 dictionary of Samuel Johnson, the English lexicographer. And by the way, I say English lexicographer to distinguish Samuel Johnson's work from the American English lexicographer Noah Webster. Most of you probably have a Webster's dictionary somewhere in your home, and that was originally written by Noah Webster, who's an American English lexicographer. And the reason why that's important is because Noah Webster, who was a pro-American revolutionary kind of guy, wanted to have a dictionary for Americans' use of the word of English as a language, not to be confused with the English way that English was used in England. And that's why you see, for example, the word defense is spelled differently in England versus the way the word defense is spelled here in the United States, because there is some technical differences between English versus American English, and that is the distinction between Samuel Johnson, who's English, and Noah Webster, who is American. But for all intents and purposes, when it comes to our Second Amendment rights, the good news is both Webster and Johnson define the terms of the Second Amendment, the text of the Second Amendment, really with the same definitions. So there's not any controversy when it comes to the right of the people to keep and bear arms as a textual matter in the Second Amendment of the Constitution. The next critical argument the court denies of Cook County's is they specifically say on page 20, they say that the ordinance imposes a tax and not a fee. That's right. The county was imposing a tax. They tried to claim this was a fee, and therefore it was not a violation of the Second Amendment or a violation of the Constitution. And I'm happy to report that the Illinois Appellate Court there in Cook County, Chicago, came out and says, no, it's a tax. Just as a quick reminder, the difference between a governmental fee and a governmental tax. Under basic constitutional law, government can charge a fee for services provided. The example I like to give is this. If you go to Yosemite National Park and it costs the government $10 for everyone that goes because they have to provide bathrooms and ranger services and some basic things like that, well, the reality is this. They can charge you a fee of $10 as long as all it's doing is covering the cost of you showing up to Yosemite National Park. But once they try to charge like $400 for something that only costs them $10, that becomes a tax because the government is now charging a amount of money over and above the cost of providing that service. And of course, that money is no longer just being spent to, let's say, keep Yosemite National Park clean. It's now going to be spent on other stuff. And when that starts to happen, it clearly is a tax. And here on page 20 of this decision of the Vandermine case, the Illinois Appellate Court said exactly that this is essentially a tax and not a fee, and Cook County cannot escape it. So now the question is, what is going to happen next? Well, what's going to happen next is this case is going back down to the trial court. I think the proof is in the pudding. You can read the tea leaves. You can see where the wind is blowing, whatever metaphor you want to use here. We're going to win this case, right? As I predicted on January 24th, we're going to win this appeal, and how I thought the case was going to come out and what the court was going to say. And if you compare with what I said in that video on January 24th with what this opinion says, I think you'll see they're really coterminous. They're really one and the same in many respects. I think the Illinois court did better than how I explained it, but they hit all the right points. So I think that this is going back to the lower court, and it's clearly going to be a square-up question is, can, under the Constitution of Illinois or under the American Constitution, the U.S. Constitution, can Cook County impose a tax on the sale of firearms or the sale and purchase of ammunition, it is clearly undeniably going to be a no, because a powerful precedent, not just at the federal level in the Minneapolis Star case in 1983, where the Supreme Court said you cannot have a targeted tax on, in that case, ink, because ink is necessary to effectuate your right to free speech and your right to free press under the First Amendment. So to the Minneapolis Star decision in 1983 by the U.S. Supreme Court, you cannot have a targeted tax on constitutional rights. Couple that with the 1960 decision, I forget the 1964 or something, Harper versus Board of Elections out of Virginia, specifically, again, another Supreme Court precedent that says a $1.50 poll tax is not constitutional because it's a targeted tax on a constitutional right. Then you're going to combine that with a decision out of the Illinois Supreme Court many years ago dealing with, I think it was a $15 tax on marriage licenses, and the Supreme Court of Illinois said that was unconstitutional under, I believe, the Illinois state constitution. So whether they try to argue Cook County under the Illinois state constitution or the federal constitution is not going to matter. At the end of the day, it's going to be a clear victory in favor of the Second Amendment, I predict, that says that you cannot have a targeted tax on a constitutional right, and that includes the right to keep and bear arms, which includes the right to acquire them and acquire guns, and also the right to acquire ammunition. So I think we're going to win this one big in Cook County. It's going to be an unusual win out there in Illinois, especially in Chicago, but I think that's where it's going to go. The handwriting is on the wall. I'm just going to keep using different cliches and metaphors here for this video. Okay, folks, hope you learned something here today. Congratulations to Todd Vandermine and the other plaintiffs in that case, and to the people involved. And we will see you again soon here at the Four Boxes Diner. Again, don't forget to subscribe at Four Boxes Diner on X. And thank you all for the nice compliments you guys are giving me for my appearances on Fox News. Those will continue, I'm sure, throughout the election year. And there you have it. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.